Hello, gym owners. I'm Matthew Becker from Lawyers PLLC. Now, before we get into the topic of this video today, I want to make it very clear that the information in this video is meant for educational purposes only. That means you cannot rely on this information as actual legal advice, and nothing in this video creates any kind of an attorney-client privilege between you or my law firm. Every situation is different and everybody's facts are different. Therefore, the individual laws that apply in your state will apply differently to your facts than they might in the facts that I present in this video. If you have any questions regarding the law and you need some education on how it applies to your individual situation, feel free to reach out to us directly at gymlawyers.com. This video is part 2 in a series of videos on who is responsible. You can go back and watch part 1 where we discuss who is responsible, either you or your landlord, when something major fails in your building like the HVAC system, the boiler, or the fire mitigation system, or the roof, something like that. In this video, we're going to talk about what happens when you're sharing a building with other companies. Something goes wrong in one of those other companies' area of the building, and it starts to negatively impact your business. Now, anytime you enter a lease or have a building that shares space with another company, it's going to open up a whole slew of potential issues. And in other videos, we'll cover those other issues. But in this one, we're focusing primarily on what happens when something goes wrong in this business and it starts to negatively impact you in this business. First, we would like to thank Affiliate Guard for this video topic in question. Affiliate Guard is a leading insurance company that provides policies for micro gyms. Micro gyms have unique needs, and Affiliate Guard knows and understands those needs. Therefore, it is set up to provide insurance policies to help you, the micro gym owner. Okay, so here's the scenario. You find a location in a building in which you want to open your gym. This is probably going to be a scenario that's going to come up mainly, let's say in like a yoga studio or a Pilates studio or even maybe a spin studio. Gyms or fitness facilities that are a little bit quieter and are more likely to be located in a building with other leased tenants. Okay, usually something like a CrossFit gym or a powerlifting gym, they try to look for locations where they're pretty isolated because they make a lot of noise. But it can apply to them too. There's plenty of CrossFit gyms out there that share buildings with other tenants. But anyway, you're sharing a building with another tenant. And you enter into the lease, you start your business and you're growing, and maybe about a year in, you've got a good membership and you're operating on a day-to-day basis, you're making some profits. And then it happens. The sewer system gets backed up in this area of the building and your restrooms start to flood. We've got a problem. What's unique about this problem is it's actually 2 problems combined into one. First, you've got the problem with the flooding. You've got to mitigate that quickly. You don't want your bathrooms flooding. It's going to start to impact membership. People are going to get mad. It's not good for business. Hopefully, there's no long-term water damage. But then second, you've got this whole other scenario over here where something is messed up in the sewer system in a completely different area of the building that really you may not have any control over the repair. So first and foremost, pull out your lease. Start thumbing through that lease and look for a maintenance section. Hopefully your lease has one. And hopefully your lease says that your landlord is responsible for everything. Building maintenance, plumbing, the 4 walls, the structure, etc. If that's the case, you're in luck. Call your landlord, tell him you need the plumbing fixed, tell him you need all of this mitigated. He has to respond to it pretty much ASAP or he'll be in breach of the lease. However, if your lease does not have this section, then you're a little bit out of luck. Now, it's your responsibility to pay for those repairs. Keep in mind, not only do you have to pay for those repairs, the water damage, the flooding, the mitigation, in your space, but you still got to pay for your lease when the next month's lease payment comes up. These can become some pretty serious issues. So that's number one. Next, you're going to want to reach out to your landlord and start inquiring about who's responsible for the repairs in the other section of the building. Unless you are extremely proactive before signing your lease, you are now at the mercy of what that lease says. Hopefully, that business owner was savvy enough when they signed their lease to put in a maintenance section requiring the landlord to fix all of these plumbing problems. If so, now you can sit back and you know that eventually those problems are going to be fixed, and probably sooner rather than later, because that other business owner also needs it to be fixed so he or she can run their business. But if that section does not exist in that lease either, now we've got a big headache. Now you have no control over the situation at all. You don't know who is going to fix that plumbing problem, and you don't know if it's even going to be fixed. If that tenant decides to leave, now it's going to be up to the landlord to fix it, and the landlord's only going to be motivated to fix it in order to get somebody else in the space. This situation can be very long and drawn out. Stuff like this can be a complete nightmare. And that's why, if you find yourself in this situation, you need to get a hold of an attorney immediately. There's going to be constant twists and turns and everything else in a situation like this, and a good attorney can help you navigate those situations. It can end up saving you thousands of dollars in the long run. Better yet, you can be proactive and try to get out in front of this before it ever is a problem. Now, you're never going to prevent problems from coming up, regardless of how much preparation you put into something like this. But there are a lot of steps you can take in order to prevent the headaches that can come with not getting the proper provisions put into your lease before signing. And that's where a firm like Jim Lawyers PLLC comes in. We have experience in the gym. We have experience in the law. We know what to educate you on before you sign so that you make sure that you're as prepared as possible for situations like this and a whole group of other situations that could come your way. Reach out to us at jimlawyers.com so we can help educate you on how to best prepare yourself so that your business can be as successful as possible.